For 30 years, GMP Law has been defined by one quality: tenacity. This is our story, told through 30 moments that shaped who we are. It started with a single office and a clear vision.
Thank you, Pauline. In November 1995, I opened GMP Law with a single office in Parramatta. I left a previous partnership to build something aligned with my values and the way I believe law should be practiced. That decision was difficult. There was uncertainty, there was strain, but then there was clarity. I was building something different.
I'd appeared opposite Gerard as counsel for the defendant, but I could see his vision, truly putting the clients first. That's why I joined within the first year. That's why I stayed.
Day one, that vision was backed by a promise.
We made a deliberate choice. No disbursement funders, no interest charges passed to clients. True, no win, no fee from day one. And that promise has never changed.
In the early years, the firm achieved a milestone that proved its promise.
Our first $1 million settlement came within the first couple of years. It proved we could deliver serious results for seriously injured clients. It set the standard for everything that followed.
The firm took on a case that exemplified its commitment, even when the system failed.
We fought for victims of Chelmsford Hospital's deep sleep therapy. Though bureaucratic delays ultimately stymied the case, it became a landmark in patient advocacy. It proves that even when the system fails, we kept fighting.
As the firm's reputation grew, so did its reach.
We expanded where clients lived and worked, not where it was convenient. Accessible justice means being there when people need you most. This set a model of client-first expansion that other firms would later follow.
Then the landscape of personal injury law changed forever.
The reforms were meant to end personal injury law, and most insurers predicted fewer claims and reduced liability. Many firms retreated. We adapted, shifting to complex, evidence-driven cases. The reforms didn't diminish our impact, they refined it.
Momentum was building. Then the ground shifted.
It was one of the most testing periods in the firm's history. Settlements stalled overnight. Cash flow froze. Clients waited.
We survived through restraint and preparation, and we emerged stronger.
The team behind the mission continued to grow.
Reaching 50 staff was a milestone that reflected our growth and our ability to attract talented people who shared our values. Every person who joined us strengthened our capacity to serve our clients all across Australia.
A landmark case tested those refined capabilities.
After more than a decade of disciplined litigation, we concluded a case involving one of Australia's earliest keyhole heart procedures, which resulted in catastrophic brain damage. The case reminds us that innovation in medicine must also be matched by accountability, and complex litigation requires sustained discipline.
Innovation came not just in the courtroom, but in how cases were resolved.
By building relationships with major retailers and insurers, we pioneered bulk settlement conferences. It streamlined cases and got better results for our clients faster.
Doing what's right means standing up to the system itself.
In 2005, we were fined for how we advertised. We were helping injured people understand their rights. If the rules prevent access to justice, then the rules need to change.
This case became a key example in professional legal ethics education and client advocacy.
While the industry clung to the past, GMP Law embraced the future.
We introduced technology that reduced paper files and streamlined case management. Technology should work for clients, not complicate their journey.
Sometimes the most important cases are the ones others walk away from.
A mother called in on a Saturday morning. Her son had suffered a severe brain injury during birth. The other lawyers she had spoken with had dropped the case. We didn't. That case strengthened our commitment to medical negligence and reinforced our willingness to take on complex matters others walked away from.
We embraced new platforms to better connect with those who needed us most.
Sometimes life happens, but if it's not your fault, you can call it fate, or you can call Gerard Malouf and Partners. Our first TV ad wasn't just about marketing. It was about letting injured people know their rights and that help was available. We believed information should be accessible to everyone.
Over the years, GMP Law has set legal precedents that shaped the industry.
In Allianz versus Cervantes, the Court of Appeal confirmed that assessing damages is an evaluative judgment. It's not a mechanical exercise or a strict formula. It requires weighing the evidence to arrive at a fair compensation that reflects the real impact of an injury.
Some precedents reveal what needs to change.
Doumit and Jabb's excavations exposed a critical gap in the law. Tracked excavators weren't legally motor vehicles and fell outside the compensation scheme. The case didn't change the outcome for Mr. Doumit, but it did lead to legislative reform. That's the law doing more than deciding cases. It's fixing what was broken.
Holding the powerful accountable has always been at our core.
In Thompson versus Bathurst City Council, the court clarified when councils can be held liable for injuries caused by infrastructure defects. It strengthened accountability and clarified how inspection and maintenance systems are assessed, making public spaces safer for everyone.
By the mid-2010s, GMP Law had touched thousands of lives.
Over 10,000 cases, each one represents a person, a family, a life changed, and a way to move forward. That's what drives us.
Most of the time, the fight is about the principle, not the payout.
A client suffered a small injury on a bus tour in the UK. The company said they couldn't be held liable overseas. We took it to the High Court. The damages were minimal, but importantly, we set a precedent. Companies can be held accountable for harm caused to Australians overseas. Some fights open doors for everyone.
The legal landscape kept changing.
The MVA scheme reforms significantly changed how and when injured people could access compensation, introducing new thresholds and time limits. While the rules shifted, our commitment to guiding clients through the system and protecting their rights did not.
In 2016, a door opened for survivors of abuse.
When New South Wales removed limitation periods for child abuse claims, former clients came back to us. We reopened their matters and secured justice for survivors. Time doesn't erase trauma, and it shouldn't erase the right to be heard.
Geography has never limited our commitment.
One of our earliest Queensland cases took me to Bribie Island after a tragic motor vehicle accident claimed a man's life. Within 2 days, I met the grieving widow in person. That willingness to go where our clients need us shaped how we grew the firm.
The firm's future was being built from within by people driven to do what's right.
This was the moment we appointed the next generation of partners. Many had started here as graduates and built their careers alongside the firm. As they began families of their own, the firm supported them. Leadership shaped by our culture, family first in every sense.
Then the world shut down.
The world did go into lockdown, but we didn't miss a beat. Cases continued and services never wavered. A global pandemic did not stop the pursuit of justice.
The firm refined how it communicated its mission.
We evolved our message from get maximum payout to maximum compensation, minimum time. It wasn't just about the money. It was about getting clients the justice they deserved as quickly as possible so they could move forward with their lives.
Decades of hard-fought cases reached a milestone.
Over $4 billion in settlements. But this isn't about a number. It's about thousands of lives changed, families supported, futures restored.
A new chapter began, taking on the powerful together.
We began taking on multi-party cases, challenging major corporations. When companies harm many, we stand with all. That's the power of class action.
And that commitment delivered results.
Exotech, defective implants affecting thousands of Australians. We secured an $8.7 million settlement, our first major class action success. It won't be our last.
the firm's reach extended across the nation.
We established a permanent office in Melbourne, my hometown, extending our commitment to delivering justice across Victoria. National reach, local commitment.
And positioned the firm for the next 30 years.
With our partnership model, the people who embody our values have ownership in GMP Law's future. The next 30 years will be shaped by the same principles that built the first 30.
These are the moments that shaped GMP Law.
When the fight was hard, we stood firm. We've challenged the impossible, broken new ground, and set new standards. And we're just getting started.
GMP Law, 30 years of fighting for you.